Thank you, loyal blog readers, for joining us for our next episode of our podcast series, The Class Action Weekly Wire. I'm Jerry Maatman, a partner in Duane Morris's Chicago and New York offices, and joining me today is my colleague from our New York office, Nelson Stewart. Welcome.
Thank you. Great to be here, Jerry.
Today, we wanted to discuss trends, issues, and important developments in the area of securities fraud, class action litigation. Nelson, this is a big space, but could you give us, from your thought leadership perspective, some kind of summary of what you think are kind of key developments in this area?
Sure, Jerry. Class action securities fraud claims typically involve an alleged public misrepresentation or admission made by the issuer of a security, a subsequent disclosure that reveals the statement or omission to be false, and a decrease in the value of the security resulting from the disclosure. Securities fraud claims readily lend themselves to class-wide treatment because the number of investors who may claim losses resulting from a misrepresentation is often considerable. The principal federal statutes for securities fraud claims are the Securities Act of 1933 and the Securities Exchange Act of 1934. Both statutes were enacted for the purpose of regulating securities markets and providing increased disclosure and transparency for investors in the wake of the stock market crash of 1929. The 1933 Act generally applies to misrepresentations made in connection with an initial offering of securities. The 1934 Act imposes liability for misrepresentations related to the purchase or sale of existing securities.
Thanks, Nelson, for that framework. By my way of thinking, the absolute holy grail in this area of class action litigation for the plaintiff's bar is class certification. They file the case, they certify it, and then they monetize it. How did plaintiffs fare over the last year in terms of certifying securities fraud class actions?
In 2023, plaintiffs were incredibly successful in gaining class certification. The plaintiff's bar secured class certification at a rate of 97%, or put another way, 35 of 36 motions. And companies secured denials in 3% of the rulings, or just in one case.
Well, when you do a comparative study of securities fraud with respect to other areas of law, at least in 2023, securities fraud class certification rates were the highest. We recently did a mid-year report in 2024 and still very high, but down to about 67%, 10 out of 15 cases certified in the securities fraud area. In terms of the key guideposts on the playing field when it comes to securities fraud class action litigation, what are some of the key developments that corporate counsel should be aware of?
One of the most notable decisions in 2023 was the U.S. Supreme Court's ruling in Slack Technologies v. Perini et al. The Supreme Court addressed a split among the federal circuits created by the Ninth Circuit's departure from a well-established interpretation of Section 11A of the 1933 Act. A plaintiff bringing a fraud claim under the 1933 Act must show that the purchase of shares at issue can be traced back to a false or misleading registration statement. The statute imposes strict liability and a lower standard of proof for a narrower class of securities than the 1934 Act, which applies to misrepresentations or admissions for any security, but carries a higher standard of proof that requires plaintiffs to show scienter, reliance, and loss causation. In Slack, plaintiffs had purchased shares through a direct listing that offered both registered and unregistered stock shares. The inability to trace unregistered shares to a registration statement would be fatal to the plaintiff's claims under the 1933 Act. In denying the defendant's motion to dismiss the class action, the district court attempted to accommodate the traceability challenges of a direct listing through a broad reading of the quote-unquote such security phrase of Section 11A. The district court held that the unregistered shares were, quote, of the same nature as shares subject to the registration statement, and plaintiffs therefore had standing under Section 11A to bring the suit. On appeal, the Ninth Circuit noted that the application of 11A to the direct listing was one of first impression, and affirmed the district court's decision while rejecting its broader reading of Section 11A. The Ninth Circuit expressed concern that the more restrictive reading of the statute advocated by Slack and applied by other circuits would limit an issuer's liability for false or misleading statements through the use of a direct listing, and thereby disincentivize the 1933 Act's goal of transparency. On further appeal, the Supreme Court vacated the Ninth Circuit's decision and held that the language of the 1933 Act was intended to narrow its focus, citing sections 5, 6, and 11E as support for the conclusion that the term such security refers back to the shares that are subject to the registration statement. SLAC confirms that the novelty of a specific type of offering, such as a direct listing, cannot excuse the well-settled requirements for claims brought under Section 11 of the 1933 Act. Unregistered shares from a direct listing or certain post-IPO offerings are subject to dismissal at the pleading stage for lack of standing under Section 11 if those shares cannot be traced back to the initial registration. Whether an issuer is required to register all shares for sale on a direct listing was not addressed in SLAC because this question had not been raised in the prior proceedings. Another key ruling came out of the Southern District of New York in a case titled Underwood et al. V. Coinbase Global. There, plaintiffs brought claims under Sections 5 and 12A of the 1933 Act and Sections 5 and 29A of the 1934 Act. Plaintiffs alleged that Coinbase operated a securities exchange without registering the securities with the SEC. Their amended complaint also alleged that cryptocurrency tokens sold on the Coinbase platform were securities as defined under both statutes. However, the issue of whether digital assets must be registered with the SEC was not determined because the court found plaintiffs failed to state a claim under the 1933 Act and the 1934 Act. Section 5 of the 1933 Act prohibits any person from selling unregistered securities unless the securities are exempt from registration. Section 12A of the 1933 Act creates a private right of action for any buyer against the seller of an unregistered security. To meet the definition of a seller under Section 12A, a seller must either pass title or other interest directly to the buyer, or the seller must solicit the purchase of a security for its own financial interest. The court granted Coinbase's motion to dismiss all claims brought under 12A because the plaintiffs did not sufficiently plead either requirement. The initial complaint had stated that there was no privity between a user of the Coinbase platform and Coinbase. The user agreement also expressly stated that Coinbase was simply an agent, and a user who purchased a token from or through the online platform was not purchasing digital currency from Coinbase. Though the plaintiffs had attempted to avoid this issue by amending their complaint to state that privity only existed between the user and Coinbase, the court held that it would not allow an amended complaint to supersede the admissions of the plaintiff's earlier pleading or the express language of the user agreement. These facts precluded an action against Coinbase under Section 12A. The company did not meet the definition of a statutory seller as defined in Section 12A because it did not pass title directly to a buyer. The court concluded that absent allegations that the plaintiffs purchased the tokens as a result of an active solicitation by Coinbase, Section 12A was inapplicable. The court further held that plaintiffs' claims of the 1934 Act also failed for lack of privity. Section 29 provides that every contract that violates any provision, rule, or regulation under the 1934 Act is void. The plaintiffs argued that the user agreement and the transactions were void because they involved contracts that were premised on an illegal purchase of an unregistered security on an unregistered exchange, which violated Section 5 of the 1934 Act. The amended complaint sought rescission of the transaction fees and the transactions. To allege a violation of Section 29B, the plaintiff is required to show that 1, the contract involved a prohibited transaction. 2, the plaintiff is in contractual privity with the defendants. And 3, the plaintiff is in a class that the 1934 Act is intended to protect. The court again found that privity was not established under the user agreement. The initial complaint asserted that the plaintiffs contracted with the users of the Coinbase platform, not Coinbase. Thus, there was no contractual privity with Coinbase. The court also noted that the user agreement was not a contract that required the plaintiffs to do anything illegal. A party to the user agreement was free to use the platform to transact in cryptocurrencies or not transact at all. The court concluded that this was insufficient to render the sale of digital assets on the platform, a prohibited transaction under Section 5 of the 1934 Act. Recently, in April of 2024, the Second Circuit reversed the district court's dismissal of the alleged Securities Act violations, finding that the district court improperly relied on the plaintiff's initial complaint and Coinbase's user agreement instead of looking solely at the allegations in the amended complaint. The Second Circuit noted that some versions of the user agreement in place when the transaction at issue had occurred had conflicting language that could plausibly support the allegations that defendants had passed title to the plaintiffs under Section 12A1 of the 1933 Act. The court upheld dismissal of certain claims brought under the Securities and Exchange Act of 1934, finding that the plaintiff's conclusory allegations provided insufficient detail to support a claim for rescission.
Thanks for that analysis. Evident to see a lot of developments in this space over the past 12 months. In terms of that monetization of securities fraud class actions, how did the plaintiffs' bar do on the settlement front over the past 12 months?
There were several settlements of over $1 billion reached in security fraud class actions last year. And the top 10 class action settlements in this space add up to $5.4 billion. In SEC et al. V. Stanford International Bank, the court granted approval of a $1.2 billion settlement to resolve investors' allegations that the banks aided Robert Allen Stanford's $7 billion Ponzi scheme. A $1 billion settlement was approved in In-Ray Dell Technologies, Inc. Class V stockholders litigation, which was a class action brought by investors alleging Dell, its controlling investors, and its affiliates shortchanged shareholders by billions in a deal that converted Class V stock to common shares. And in In-Ray Wells Fargo & Co. Securities litigation, another $1 billion settlement was approved in a class action brought by investors alleging that the company made misleading statements about its compliance with federal consent orders following the 2016 scandal involving the opening of unauthorized customer accounts.
It seems like 2024 is equally upbeat for the plaintiffs' bar. We've tracked through the first 6 months settlements totaling over $2 billion, with 3 individual settlements tracking near the $500 million mark at $580 million, $490 million, and $434 million for securities fraud class action settlements. So very robust area for the plaintiffs' bar. Well, thanks so much for your insights, Nelson. Very, very helpful in this space. And thank you to our loyal listeners for tuning in to this episode of the Class Action Weekly Wire.
Thanks, everyone.